Today we'll be discussing the Article 5, specifically the Article 5 Convention for amending the U.S. Constitution. For those of you unfamiliar with Article 5, it's the section of the Constitution that describes how to change the Constitution, how to amend it. And there are two ways to do so. One is by Congress proposes those amendments, which then the states ratify, or the state legislatures could apply to Congress for Congress to call a convention or a constitutional convention where the delegates to the convention would make the proposed amendments or perhaps even a new constitution. And joining us here to discuss that movement for those who are wanting this, mainly the Convention of States organization, to speak out against those efforts is Shawn Meehan, the founder of Guard the Constitution. Thank you, Shawn, for being back with us here at the New American.
Christian, thank you for the invitation. I appreciate all that JBS and Bill Hahn and your group do out there to push for conservatism and to guard our Constitution. Enjoy working with you.
Thank you, Shawn. So we've had some major seismic developments with regard to a constitutional convention under Article 5, the advocates of which refer to it as a convention of states since, for the past 10 years. During the September 15 program of the Glenn Beck program on the Blaze TV, Glenn Beck made the following unexpected announcement. Let's play the clip.
I have been a supporter of the Article 5 Convention of States. I've been a pretty big supporter, vocal supporter. I'm reversing that today because after some real thought and prayer, we are not the people to open up this sacred document. We are not the people. That was a God-inspired document. That was divinely written, and you can read it from I don't know how many founders. Benjamin Franklin even said that. The very hand of God was involved in the writing of that document. Do you believe that we could send delegates to a convention today that would have that kind of inspiration, that when they got to an impasse, somebody would be there like Ben Franklin that would say, let's pause and all go to church and pray? And they didn't politic, they prayed. I am not for opening that Constitution anymore because we are not the people. When we are the people, I'll be for it again. When we have demonstrated our humility and our obedience to God, and I'm afraid it's just going to take a massive beatdown of our country to get to that place. But someday we will be humble enough. We will recognize God. We will not be an enemy to God. We will not be so arrogant. And when we're those people, I will support the Convention of States. But I withdraw my support. And I'm sorry to say that, but I withdraw my support. But it is because of the fact that this Constitution is wholly inadequate for anyone other than a religious and moral people. We are not those people, and we should not stain this document.
So, Shawn, could you explain just how significant this is and what it means to the debate about whether we should have a convention or not?
Well, to me, when I was first made aware of it, I was very pleased because Glenn Beck has a very broad audience with patriots and people that are conservative. When I was stationed in Mountain Home, Idaho, outside Boise in the early 2000s, I used to listen to him on the way home. And his radio program and his various other media has quite an audience. Several people that are active in politics that I know actively listen to him. Also significant is that he indicated of how he came about this decision. It was from research, contemplation, discussion, and importantly, prayer. And I think that's hugely important because he also, I think it's for about 9 years, he was one of the earliest supporters and most consistent over time of the Convention of States organization. So him as opposed to many other endorsers of theirs, changing his position, I think that's hugely significant.
Absolutely. And shortly after Glenn Beck made that announcement, Rick Santorum and even Mark Meckler, the president and co-founder of Convention of States, went on Steve Bannon's War Room program. In fact, in an interview on Steve Bannon's War Room, former U.S. Senator Rick Santorum, who now lobbies on behalf of Mark Meckler's Convention of States organization, said the following.
But here's the reality, and I talked about this. I've been talking about it for years. You have to. Which is the Constitution has been amended many, many times prior, other than the 27 amendments that have actually passed and been ratified by the states. What's happened over the last 100 years is that the Supreme Court has amended the Constitution to allow the federal government to do things that it was never permitted to do under the Constitution.
Is Senator Santorum correct? Has the Supreme Court permanently altered or amended the text of the Constitution to enable the federal government to essentially get away with whatever it wants to do over the past few decades? And is a convention the only recourse for states to overturn these Supreme Court amendments, if you will?
Absolutely not. And Senator Santorum is doing what I believe he was paid to do by Convention of States, is be a spokesmodel. But he just seems to be very unaware of the truth of the issue and reading from talking points. I have my pocket Constitution in front of me with 27 amendments, and I'll hold it up for the viewers. It's still pretty thin. Of course, they'll hold up their book of the Constitution Amended, which is a compendium of a summary of Supreme Court opinions, and they call that an amendment. We're talking about Article 5, the actual article that talks about how to amend the Constitution. And nowhere in there do I see Mark Meckler's name, Rick Santorum's name, or the Supreme Court. And I would actually really quickly like to read a quote from the book, The Activist. And you need to have your readers get a hold of this. It's The Activist, John Marshall, Marbury v. Madison, and the Myth of Judicial Review. It's by Lawrence Goldstone, and it says, if there's a seminal case in American jurisprudence, it is Marbury. The Supreme Court's unanimous decision in that case, rendered by the Chief Justice, not only established the right of judicial review, but also drastically redefined the notion of separation of powers that had emerged from the Constitutional Convention 16 years before. And I'll leave that there, but I think that was a major theft of power that has resonated through the history of the United States. Article 5 describes how the Constitution's amended, and nowhere does it give the Supreme Court or the judicial branch that authority. The Constitution has only been amended 27 times, and all we need to do is defend it, not amend it to enforce it.
Well said, of course. And, Mark Meckler, the co-founder of COS, he often repeats the exact talking point when selling people to buy into the idea of an Article 5 convention. Among his most repeated talking points is this one, which he said during an interview on Bannon's War Room.
Yeah, and I would say it's not a theory. This is just fact. If you read Madison's notes 2 days before the end of convention, September 15, 1787, Mason stands and he says, we have a problem. We've given the power to Congress to propose amendments, but not the same power to the people acting through the states. And he says, are we so naive to believe that a federal government that becomes a tyranny will ever propose amendments to restrain its own tyranny? And we know what they said. His comment there is nin com, which is Latin, short for no comment. Nobody argued, no debate. They said, we're going to have to give the power to the people to restrain the federal government constitutionally, and that's what we're doing.
Is Meckler accurately describing what was said during the convention relative to the creation of Article 5 in the current Constitution?
The basic event happened, but anything beyond that, the way that Meckler describes it, is incredibly devious and self-serving and misleading. Non-con is Latin for without objection. It does not mean unanimous, like he says. And there were, I think it was 7 motions right after Article 5 passed. And these are documented in the notes in the Journal of the Convention. One of them was actually to repeal the entirety of what they had just done. And before then, there actually was debate and discussion of whether or not they wanted to actually do this. There was questions about, Mr. Madison did not see why Congress would not be as much bound to propose amendments applied for by 2/3 of the states as to call a convention on the application. He saw no objection, however, against providing for a convention in the purpose of amendments, except only that difficulties might arise as to the forum, the quorum, etc., which is constitutional regulations ought to as much as possible be avoided. That sounds like debate to me. And actually, Christian, I know several nationally registered parliamentarians, and I asked them, I said, if you read these September 15th notes of the Journal of the Convention and look at them, can you say there was no debate? They say absolutely not. No debate in parliamentary worlds is where a motion is made, a motion is seconded, and you move immediately to the vote with no further discussion. There was debate before the motion, there was some debate after the motion, and there were efforts to amend what they had just done after. That is simply a convention of states deceptive marketing psychological trick when they tell people there was no objection and it passed unanimously. That is just to mislead and to get you on board and excited.
You know, and another one of COS's favorite talking points that's often repeated by Mark Meckler and even Santorum is that we've had 20 convention of states, they'll say, in the past in this country, and they've all been for limited purposes, and the courts have held them to it, right? That's what they say. So in other words, if we have an Article 5 convention today, it won't be a runaway convention because look at all the conventions of states that we've had before. So have we really had these 20 conventions of states that they claim? And do those conventions bear any resemblance or significance to what we're discussing now in the form of having an Article 5 constitutional convention?
Well, it's hard to accurately answer that question, Christian, because as you know, for almost 9 years, I've focused specifically on this issue nearly full time. And I've never seen the Convention of States organization, Robert Nadelson, their attorney, or anybody tell me which conventions are you talking about? You know, if you're making such a bold central claim to the thesis of what you're promoting, should you not be able to provide the evidence? And in fact, there was a Pennsylvania state convention in 1873, and I'm going to quote from Constitutional Brinkmanship, Amending the Constitution by National Convention by Russell Kaplan. It's one of the nerd books, if you're into Article 5, that goes into a lot of the details. And it says, when the Pennsylvania Convention of 1873 proposed a new constitution, this is a state constitution, along with changes in the Bills of Rights that went beyond what was sanctioned in the Enabling Act. That's a runaway. They went beyond what was sanctioned in their Enabling Act. Lawsuit was filed to prevent submission of the new Constitution for popular ratification. The Pennsylvania Supreme Court admitted that the convention had acted ultra vires, which is legal speak for outside their authority. But before the case was decided, the Constitution had been submitted to the voters and was approved by a large majority. Said the court, quote, the change made by the people in their political institutions by the adoption of the proposed Constitution forbids an inquiry into the merits of the case. The question is no longer judicial. They exceeded their authority. The court recognized that. The people ratified it, and it was the Constitution, and the court said they couldn't touch it. So I'm guessing that when Mr. Santorum and Mr. Meckler put this propaganda out there, they neglected to review that reference.
Good point. Also in Bannon's War Room, Santorum also said the following.
Each state, because it's a sovereign entity at a convention of states, gets one vote, which means that 34 of the 50 delegations will be controlled by Republicans because the 34 Republican state legislatures are going to have to pass this thing.
Now, Santorum's claims that each state gets one vote at a convention is closely related to how even COS describes the convention itself. They refer to an Article 5 convention as a convention of states rather than the historically accepted term of constitutional convention to describe it. So I ask you, Shawn, is an Article 5 convention really a gathering of the state legislatures, a so-called convention of the states?
In some small way, you could say that it is, but the way that they sell it, absolutely not. It's deceptive. And for Santorum to say the sovereign states. Boy, that's a very clever psychological ploy to reach a lot of good grassroots patriots, that we understand the concept of a sovereign and sovereign states and things like that. But if you look at the American Legislative Exchange Council, who's one of the deceptive sales groups for Convention of States, Rob Natelson, the Article 5 premier attorney, according to Convention of States, he says that initial suffrage is one state, one vote, with decisions made by a majority of states, but the convention may change both rules. If you've ever been to any kind of a convention and you've seen people try to be deceptive, there's draft rules that are usually finished late the night before. And if someone wants to do something nefarious and it's a couple pages long, they just shove it in there and they hope that delegates never see it. Or you can even have people drinking their orange juice in the morning, not paying attention. You can amend draft rules. I've seen this done at political conventions for people to do their not fully transparent tasks, if you will. I also ran a spreadsheet a couple years ago looking at the populations of the various 50 states and which states would want to get together using a one state, one vote model, but altering to be a population allocation model after the fact. They could actually use a one state, one vote draft rules or initial set of rules to then amend to a population allocation. And then we have the nightmare of New York and California and some of the other left-leaning states running a convention. And for them to make this argument broadly, to be fair, I think there's a more than not chance that it could be one state, one vote. But to sell that as a huge security blanket, absolutely not.
So in your estimation, there is no guarantee then that it'll be one state, one vote. It could very well be popular by the popular vote of each state.
Absolutely. And I think it's important to point out that Congress has attempted to pass laws in the past defining what a convention would look like. And the Senate passed one. It did not pass all of Congress back in the late 70s. That clearly defined basically an electoral college population-based allocated model. And in fact, I think it actually mirrored the allocation of what electors would be. So that is a hybrid, but yes, population-anchored model. Convention of States will say that's not what will happen. We control the convention. Congress doesn't. They're ministerial. That fact's not in evidence is what an attorney would say at that point. That is not clearly decided. Population-based voting is a very real risk at a convention.
Now, according to the text of Article 5 of the Constitution, it reads that any proposed amendments, quote, shall be valid to all intents and purposes as part of this Constitution when ratified by the legislatures of 3/4 of the several states or by conventions in 3/4 thereof, as the one or the other mode of ratification may be proposed by the Congress. And so in his appearance on Bannon's War Room, Senator Santorum also said,
final point, and this is really important.
Yep.
Any proposed amendment that comes out of this convention has to be ratified by 38 state legislatures. So here's what I would say to anybody who's concerned about what could happen at this convention. Name one amendment you're concerned about that could get 38 state legislatures to ratify.
So of all of COS's talking points, none is more pervasive, I would say, and repeated than that particular one. Does this COS talking point pass muster to you?
Absolutely not. And you would argue by how loudly they try to proclaim it, that it's a huge selling point for them. I'd like to remind the viewers that Article 6 of the Constitution contains the Supremacy Clause. And it says that this Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made, or which shall be made under the authority of the United States, shall be the supreme law of the land. And we're having this entire discussion and having to defend against this deceptive movement by Convention of States and others. We all agree I agree with Mark Meckler that our Constitution is not being followed, but he's not pursuing the proper solution. So I ask your viewers, if we're not following the supreme law of the land, the Constitution, how can you tell me that any rules will be ratified properly and followed. The ratification process that was required in the 1787 convention absolutely was not followed, and there's plenty of documentation on that fact. And it's very reasonable to assume that things would change here. How would they change it? That's not important. The thing is, this is not needed. We know the Constitution is not being followed. If we know it's not being followed, we know what it actually says and how to follow it then. And I like to ask my friends in the Convention of States movement, is they say no bad amendments will ever be ratified, but they will agree with us that the 16th and the 17th Amendment were ratified and ought to be repealed. And for bad amendments, and it doesn't matter what your view is on alcohol, is should alcohol have been banned in the Constitution of the United States? Really? The 18th Amendment was so bad, you know, of the Al Capone, the crime, and the bad results of it, that with about 10 years later, they had to pass the 21st to repeal it. So we have a history in this country where we would agree with the Convention of States people that bad amendments have been and very likely could be ratified. So again, it's just marketing, an appeal to the ignorance of the people, and the way that the founders taught us to fight that is the Constitution is very simple. Read it, learn it, unite with organizations like John Birch Society and others, and fight the deception, and we can move back towards our Constitution being followed.
Thank you so much, and you put that quite well said. So where can people go to find you, Shawn Meehan, your organization, Guard the Constitution, learn more about what you're doing, support what you're doing, or even book you as a speaker in their area if that's an option? So where would you direct them to?
I would send them to guardtheconstitution.com, and where I'm able, I'm happy to help out. And I would encourage people to learn this issue more and get involved themselves. I just went with some fellow Douglas County, Nevada Republicans yesterday to our Douglas County Young Republicans at the high school, and we talked about the Constitution. And Christian, I'm worried for the future of our country, except when I talk to some of these young people. We have to cultivate them, mentor them, and guide them. But the love for what America stands for is out there.
Thank you so much, Shawn. Take care. May the Lord bless you in all of your efforts, and we'll see you again next time.
Christian, to you and all of my friends at John Birch Society, keep doing the great work that you do. Thank you for the invitation to be with you this morning, and everyone have a fun and safe weekend.